Hi, I guess we're live right now. So I guess we're beginning. Okay, sorry. This is the first time I've done live with this platform on StreamYard. I'm really excited to be a part of the Texas legal program to talk today to everyone with regards to estate planning. And I'd like to have my conversation be a little bit different in regards to the idea. I'm not going to really be spending a lot of time talking about why you need a will, because what I like to do is to really help you understand how the will works as a function of a larger estate plan. And so my present today, talking about plan for growth, this idea of succession planning as opposed to simply just estate planning, because I actually like to talk to everyone really about the idea it's a continuity. And so what do I mean by continuity? Well, first, before I begin, I want to really think about this idea that what are we afraid of? What keeps us up at night? And this is what really drives this idea with regards to why we need to have these plans in place, why we need to start thinking about them. So what typically are we most concerned about? Well, first and foremost is this idea of who is going to take care of me. Because, again, we're living in relatively unprecedented times, yet at the same time, it feels oddly familiar, oddly predictable. And that's to say, natural disasters, poor health, economic downturns, all of these are things that we've seen before as a community. And so it's nothing new by itself. Maybe it's more drastic than we've ever seen or witnessed before, but again, is it really all that new? And so when we think about who's going to take care of me, will I have enough money when I retire? Who's going to be able to talk to my doctor if I'm sick? Do I need to be kept on life support? Again, all of these questions are things that we think about as it concerns ourselves individually. Another question that usually keeps me up at night is, again, who's going to take care of my family? If I should die, will my family have enough money to be able to take care of themselves? Will I be able to afford for my children to continue to go to college when I'm not making any money? Will my wife be homeless potentially, right? And so all of these questions are not just about myself, but really about my larger family. And ultimately speaking, how will I be remembered? We're a little bit narcissistic, we're a little bit egotistic, but ultimately speaking, we want memories of us to be able to be passed through to our families in one way or another. And so will my children be fighting over money? Will my family respect my final rights? How will ultimately my family remember me? So again, keep these questions in mind as we continue to move forward with this presentation, because the idea is we want to make plans that we decide, not somebody else, least alone a judge, least alone the legislature. So how to make plans? Well, again, I want us to really rethink this idea of estate planning. And how do we do that? First and foremost, we need to understand how assets actually get transferred. It's one thing to have a will, but it's another thing to understand how the will, how the probate, how these documents actually move title of a real estate property, or let's just say a bank account, from one person to another. Secondly, it's to understand the limitations of our estate plans, because again, a will only goes so far. And that's to say a will has to be probated, recognized by a court at law, and have an administrator nominated and determined by a judge. And so there are actually assets that go beyond the control of the will itself, beyond judicial control and supervision. And lastly, we really want to think about whether the plan that I have in mind is actually the intentions that will be carried out. Because a lot of times, a lot of my clients will come to me and say, I want my kids to have 50-50 if both of us pass away. What does 50-50 mean? If you only have a car, does 50-50 mean that you have somebody sell the car and give cash? Or are you literally thinking about someone taking a chainsaw and splitting the car in two? And so we need to think about how the plan actually works. So let's begin with our first topic, and that's to say, exactly how does my assets transfer from one person to another person? Well, so let's think about real property, because for the most part, our largest assets are going to be the real estate, our home. And so we want to think about how real property actually ends up being transferred from one person to another. Because we live in Texas, and that means it's a community property state. And so the common notion is, well, if I'm married to my spouse and we're community property, we're already 50-50 owners. But does that actually mean that the property transfers from me to my surviving spouse upon my death, automatically upon death? And the answer is not necessarily. And so when I talk to family members about the actual transfer of real property or relative real estate, we have to think about what happens with regards to the sale of property subsequently. Or another put away, can my wife sell the house by herself? And the answer will really vary. So first and foremost, really think about where the property is located. It's a lot easier to have everything located all in the state of Texas. But it's another thing if you have property suddenly in California, in Oklahoma, in Louisiana. And the reason why is that real property is only controlled by the jurisdiction of which you're in. And so again, if I live in Texas, I die in Texas, and my family goes to probate the will in Texas, Texas court's jurisdiction is limited to Texas. What happens if I have a property in Louisiana? Well, I don't know, because I'm not a Louisiana attorney. What I do know is that they're going to have to take the Texas will that's been probated, get those letters, and then drive to Louisiana and get a court in Louisiana to approve the same thing. That seems a little bit onerous, and it is indeed tedious. And so really think about where your property is located. Even if we're talking about Dallas County and Collin County, where you end up residing really has an effect to determine how easy it is to be able to sell. So secondly, let's understand and review how property has been received. And that's to say is a lot of times people think, again, oh yeah, if I die, my wife automatically gets my house. Well, is that what the actual deed says? And so when I look at the deeds, I first look at who sold the property, who received the property, and how they took it. 9 out of 10, and probably 99 out of 100, it's actually as husband and wife, period. That's it. And so that's not actually the same thing as husband and wife taking as joint tenants with rights of survivorship. Because if the deed is missing those magic words of rights of survivorship, and specifically joint tenants with rights of survivorship, title companies won't recognize the successive transition of that property. Moreover, was the property ever identified as separate property or community property? I do have clients from time to time where they buy the property because it's an inherited gift of cash, and they want to buy a separate property, but really keep it as separate property. But if you buy property as a married couple, doesn't matter where you get the money, that new acquisition of title becomes presumed to be community property. And so identification is so key. And at the end of the day, it really just comes down to the question, can I sell the property? Will a title company insure title, underwrite it, and allow a good title to be passed to a bona fide purchaser? And I know I'm using a lot of words here, but effectively, let's just shorten it down. Can I sell the darn thing, right? And so from time to time, you may need letters of administration or letters testamentary after probating a will. But there are other ways to sell property. Maybe it's through an affidavit of heirship in which everyone simply files a paper and says, this is who the heirs are. Will that be satisfactory to a title company? Will the underwriters recognize that? Again, your case may vary. Sometimes with an affidavit of heirship, it often requires that all beneficiaries or distributees all agree. And that's to say, if mom and dad die and then they left behind 7 kids, guess what? All 7 kids have to agree on the sale of the property. So again, understanding how title actually passes from one person to another is really key to understanding why you may want a will or whether or not a will even applies in your situation. For other people with business interests, again, you're going to have to look at your operating agreement. And the reason why is this. When you die, there's no one necessarily alive to be able to sign that new corporate resolution. There's no one able to tell the bank that who the new managers are. And so will you have the ability, whether as the administrator of the estate or as simply being a surviving member of a sole member LLC, that you'll be able to dictate who the new managers are, who the new signatories of the bank accounts are, who has voting rights? And for people who have multiple partners, you may want to really consider key person insurance. I just recently spoke with a prospective client where they have a business together. There's an age discrepancy between the two owners. And my very first question is, if your partner died, would you want that spouse to be a voting member of your new company? Or would they just receive interest in the sense of all profit shares, 50-50 would be divided? Have you really given it some thought? And the answer, unfortunately, was no. And so my first response back to them was, talk about, then come back to me. So ultimately speaking, when you think about business interest, think about how many people are involved. Will partners disagree? It's one thing when you're the only member and the only person who is making decisions would be the surviving spouse. But what happens if there are multiple partners involved and suddenly I'm going to use your death as an excuse why I'm not going to recognize your interest, your voting shares? So let's think about that. Beyond that, let's think about transferring of financial assets. And that's to think about your bank accounts. Think about your retirement accounts. Think about your 401k, your insurance policies. Because again, these accounts don't automatically transfer upon your death. And I just spoke with yet another client this morning, which said, oh, you know, when mom died, she and I were joint account holders, so we're taken care of. And my first response back was, but you just said you had 3 other siblings and your father is still alive. And so are you certain that you really owned what you took? Because there are other people who can claim that that was part of their money. So with bank accounts, it's really interesting because we go back to this whole question of access and ownership. And so what that means is when we're dealing with property, it's one thing when you have ready access to be able to transfer funds, write checks, open up bank statements, that's fine. But do you have the legal ownership to claim that the entire account is yours? And so that's where we really have to look at your family situation. One person who inherits everything, generally not a problem. Multiple family members, you can bet that people are going to start fighting over money. I've never had a case where everyone just says, no, there's not an issue. At some point in time, there's going to be some slight disagreement, even if it's a question of who's going to get the pot holders. And so with financial institutions, you have to go back and really think about how the property is titled. Is it 1 or 2 people that's as joint account holders, which means they have 50-50 ownership, but unlimited access to each other's money? Or do we have a situation where it's more of where I am a signatory on my mom's account? That means I have the ability to withdraw money, but I don't have any other rights to the money itself. It's the idea of a true convenience account. I don't own anything. My mom owns 100% of this bank account, but I have access to it to take money out on behalf of my mother. And so this is where pay on death beneficiary designations are really important, because for a lot of family members, the fastest way to ensure that your property goes to your spouse or to your adult children or to another family member who needs it directly. Again, if I put a POD designation on that account, they own the property. They own that account assets, the underlying cash inside those accounts upon my death. But there are other ways to transfer. We could still go through your typical letters of administration or letters testamentary. We could even consider a small estate affidavit. There are other ways to access that cash. It's just a question of how many people do we need to sign off on it. So let's spend a little bit of time talking about this idea of probate versus non-probate. And the reason why I'm going to this extreme length is because, again, you can write a will, but if you don't understand how that will actually is used or recognized by a court or by the financial institutions, then do you actually have a plan in place? Because it surprises a lot of my prospective clients when they learn that not everything goes through probate. So what's not in probate? And it'll surprise you, a fair amount. Number one, life insurance and death benefits. If you have a life insurance policy and that policy designates a beneficiary, that is not a probate asset. That gets paid directly to your beneficiaries outright by rule of contract. It doesn't matter if your will says to Johnny. If your beneficiary says to Danny, it goes to Danny. Doesn't matter what your will says. What else doesn't matter? Your retirement plans. Under federal law, retirement plans typically are going to be considered joint owners with regards to your spouse. And so most retirement plans, when you open up an account or you start funding, whether it's IRAs, 401s, SEPs, or the equivalency for teachers, I forgot the name right now, pension plans, they all have a beneficiary designations that when you open that account, they're going to ask for it. And so if these accounts have beneficiary designations, guess what? It doesn't matter what your will says, it goes to the beneficiary designations. Bank accounts and other institutions. So if you have Vanguard, TD Ameritrade, Fidelity, Edward Jones, or any number, who are the new ones, Venmo, Coinbase, Robinhood, any financial accounts that allow you to designate a beneficiary, what's referred to as POD, guess what? That also goes to the beneficiary regardless of what your will says. Assets held. So when we talk about real estate, if there is joint tenants with rights of survivorship, if there's one of the new transfer on death deeds, or if there's one of the old school ladybird deeds, which is also referred to as a special warranty deed with enhanced life estate, those are all also automatic designations upon death. So if your real estate property have any of these designations that's recorded with the county, it's not a probate estate. Lastly, anything in the trust. So if you really think about everything that you owned from 1, 2, 3, 4, 5, and if everything's inside there, then what's left for probate? And that's the mistake that I see a lot of people have. I want everything to go to my kids 50-50. But if 50-50 ends up being the car that we haven't mentioned, and everything else already has beneficiary designations, then did you properly designate everything as 50-50? Otherwise, you may have just made a mistake. So again, think about 1, 2, 3, 4, 5. Let's take a hypothetical family, right? We take a prototypical historical family, right? Again, husband and wife, or rather just two spouses with 2 adult children, right? So it doesn't really matter if it's really husband or wife, but ultimately it's just spouses. Everything is community property. That's the homestead residence, financial savings, retirement accounts, car, life insurance from husband to spouse. In general, I pick on husbands because men tend to die first. The average life expectancy for an American male is 71, women is 81. So statistically speaking, I'm going to pick on the guys first. So how does that ultimately get divided? Well, if the husband writes a will, and what's usually referred to as a sweetheart will, which everything goes to the surviving spouse and everything is left then to the children, what ends up happening is that all of these financial assets ends up going to the wife, right? And so the wife would take the entirety of the house, the car goes to the wife. But if there are other designations, right, and we go back and I jump back and forth, right, the retirement accounts, the savings accounts, if they designate to the adult children upon his death, then technically half of that goes with the kids, right? His half would go to the children. So 25%, $25,000 of that financial savings account, 25,000 of the retirement savings account, all goes to the kids outright and never actually goes to the surviving spouse. So what happens then, again, take it one step further, what happens if they get divorced, but they don't change any designations, right? So in the similar situation, we have a problem because while the will itself would treat the wife as being predeceased. So the wife in a divorce proceeding would retain her own 50%. And the rest of it, the house would go to the adult children 50-50. But again, I've died. I've left the designations for most of the financial accounts the same, especially for the bank accounts. Then they go whoever it is. So if the husband accidentally named it to the spouse and never changed it, those bank accounts that we talked about, the financial accounts, the retirement accounts, they still go to the wife. But that's not what they probably intended after divorce. I generally don't find that husband and wives after divorce still give everything to their ex-spouse. The one difference would be the life insurance policy, because life insurance policies upon divorce automatically voids the spouse as a beneficiary. Again, think about that. So what I want you to think about after we've gone through this kind of exercise of understanding how assets transfer from one person to the next is think about what it is that you ultimately want. What is it that you want for your family? Because if you don't have a will, the good news is that there is a will. It's called the Texas Estates Code. The legislature, in its infinite wisdom, has written everybody's wills. The question is this the will that you intended? Maybe it is, maybe it's not. By default, Texas law says community property all goes to the surviving spouse so long as all of the children are of the same marriage. But if you have children from other marriages, then the community interest of the deceased spouse goes to his or her children in equal shares. So if a man dies with 5 different kids, 5 different marriages, then each kid gets 20% of whatever he owned. And that 20% would be 50% of whatever was community property, and therefore each of them gets to 10%. Now, I never realized I went into law thinking that I would be doing so much math, but I am. There's a question is, would it not be better to include a beneficiary on a 401k and in life insurance so the will is the default? And that's a question of intent, meaning one of the things, and I'll talk about, and actually let's talk about this right now too, which is probating a will still takes time. If you're in Dallas County, it takes upwards of 4 to 6 months to even get before the court today. Collin County maybe takes less than 2 months. Tarrant County takes 3 months. Harris County can take upwards of 2 to 3 months as well. And so is it not better to have everything just go to your estate instead? Well, it's a question of how quickly you want cash to be given to your family. One of the things that I end up doing, and I recommend for a lot of folks, is to stagger out the payments potentially. If I have bank accounts that are really where all of my checks goes to, all of the life insurance possibly would go to, that's not a big question ultimately. And so it would be easier to just designate the surviving spouse or maybe an adult child, if you're single, to be that beneficiary so they can take that money outright. Because how else are you going to pay for funeral expenses? How else are you going to pay property taxes? And again, a fun story, which is we recently dealt with a probate of an estate. We sold the house and we realized we knew we had property taxes that were owed. But the problem we didn't realize at the time is the title company forgot to pay all the taxes the year that the family member died. So they paid all 2021 taxes, but they forgot the 2020 taxes, which ended up causing a big headache for us because we kept getting all these tax bills afterwards, realizing that nobody paid taxes. And so if we didn't sell the house, and even if we did sell the house, we needed extra cash available just to deal with the taxes. So the question again asked, and long story shorter, is there may be some benefits of designating things to be governed by the will, but there may be benefits as well where, because of liquidity, the quickness of how POD beneficiaries can be distributed, you may want to think about that staggered payment. Because again, a will by itself does nothing. A lot of people will say, well, I'm named as the executor of my mom's will. So my first question afterwards is, well, did you take it to probate? Because if you didn't take it to probate and you don't have letters, you're not the executor. And a lot of people realize, oh, and the second thing they also say, oh, by the way, mom died 5 years ago. And I said, that will's useless now. By law, you have to probate a will within 4 years of someone's death to be able to open up administration. And if you don't, you're stuck into purgatory, which we call dependent administrations. So, going back to that slide to kind of think, decide what's best for your family. I have a lot of family members sometimes, especially in our COVID environment, in which we don't write wills. We deliberately, intentionally don't write wills. Why is that? Because the person is in their deathbed. That's the last thing they want to think about. And so we verify the family. Are you married? Okay, surviving spouse. Do we have kids? Are all the kids of the same marriage? Okay, we're taken care of. We're good. Let's not bother grandfather with having to write a will, because guess what? We have other ways to deal with this. But if we're dealing with families or mixed family situations in which, for instance, there are multiple children, maybe even estranged children, Texas default law might be the worst thing possible. Because if you have children, for instance, that are predeceased, and that's to say some of the kids who died before you died, then it goes down to their children. And so recent example of why we learned the hard way that what we thought was going to be easy ended up being a kind of a slight nightmare. We had a will, but we decided that, you know what, because we wanted to save a little bit of money, we weren't going to probate the will immediately or wherever. We were going to just have everyone agree to sell the house. This was December of 2020. We thought it was going to be everyone who would agree to sell the house. What we didn't know was that 7 months later, one of the children, not even the children, it was one of the grandchildren, would be unavailable for any number of reasons, that they would not be able to sign documents. Again, we could not have predicted the future in December, and we realized later on that it was a terrible idea to have thought that everyone would be able to sign documents. So again, think about that. Next thing to think about, of course, is children. That's kind of on the bottom of my slide. And here's why. A lot of people will designate their minor kids, kids under the age of 18, as the beneficiaries, usually as contingent beneficiaries. But the problem is this: minor children can't own property. An insurance company just can't cut a $1 million check to a 12-year-old child. So what do we do then, right? We need to set up specific designations to ensure that children can receive property by way of an intermediary. Oftentimes, whether it's referred to as a guardian of the estate or whether it's a trustee. But again, there has to be a mechanism to transfer property. So let's talk a little bit about planning for your family's future. As a point of reference, a lot of people come to my office asking about the estate tax because they're really worried about the estate tax. And I ask them, do you have $12 million? And if they say yes, and it's like, great, I'd love to talk to you more. Are you married? Oh, well, then don't worry about it. Because again, if you're married with $12 million, then community property divided by 2 means $6 million. You're still well under that exemption limit. Husband and wife, $23.4 million right now. But even if we go to 2026, that goes back down to $6.8 million adjusted for inflation, which makes it 13.6 per couple. Even if the Biden plan passes through and we go back down to 2009 levels, which is $3.5 million, we're looking at $7 million collectively between husband and wife. The only exception that I would say don't worry about estate taxes if you're a non-resident alien. So if you don't have a US passport, you don't have a green card, and you also don't live in the United States, and you have money here in the United States, well, tough cookies, because you only get $60,000 as exempt. I always go back to 2017 because 2017 was right before we passed the Job Cut and Jobs Act under the Trump administration. And so even back then, only 2 households out of, sorry, not even a household, 2 estates out of every 1,000 paid estate taxes. And this is when we were in the $5.6 million exemption era, right? So if less than 0.2% pay taxes, how many families would have to pay federal estate taxes after we doubled it to 11 million? By way of example, what we've seen historically speaking for estate taxes is that the exemption amount has gone up and up and up. And you'll notice that there's two columns. One is about the estate tax and the other one's lifetime exemption, which is simply to say, I can give a lot of money away. I can give up to nearly $12 million tax-free. Otherwise, I'd have to pay 40% on any tax I give. So again, there is some questions with regards to tax planning, but for the vast majority of Americans who are under $12 million today, you may not think that the estate tax is important, and generally it's not. And so that's why I tell everyone, I don't care about the estate tax for the most part. What I care about is access and control. Who is going to be able to control the assets, to transfer the assets? That is more important than worrying about an estate tax that never applies for the most part. So don't be afraid of probate, right? When we make our plans, don't be afraid of having your will go through probate, because even by comparison, when I said Dallas County, we're looking at anywhere from 4 to 6 months to get a court date. That's still faster than a year or 2 years in other jurisdictions. California, I've heard, takes nearly 18 months, and their costs are really, really high. And so probate in Texas, because we have independent administrations, and what that means is that the judge doesn't need to approve every sale, every transfer, every distribution. The judge just basically says, you're in charge. I trust you to do your job. Just file the compliance paperwork later. Yeah, we'll be fine. That's an independent administration. And if you do it without bond, which means you don't have to put in insurance, like be bonded or with a surety bond, then it's even easier. So it is still really convenient. But the reason why you really shouldn't be afraid of probate probably would be, how else will you let anyone know what you want? I've seen so many families which we fight over things because dad said before he died. And the operative word is dad said. If dad put it in writing, whether it was in his handwriting or something else, we'd at least have something to work with. Because if dad just said, I want you to have my car, but he's got 2 cars because he owns 2 cars with your mom, what are you going to do? Which car did he talk about? It is really important that you have some sort of writing in place so that you can clarify your intentions so other people will know. I've been blamed a lot by my wife for the fact that nobody seems to understand what I'm telling people sometimes. And that's because I tend to ramble. And if that's the case, good luck trying to figure out what my estate plan is if it was just all oral. Having a written document of some sort allows and guides your family to understand what they should do. Again, you've got to build a treasure map. I hate to say it in that way, but that's what it is. You've got to lead people from step to step to be able to understand what they need to do to be able to access the assets that you've collected under your name. And again, at least you want to do an independent administration, which the judge doesn't have a voice in, because a dependent administration is far, far worse, or even a receivership. And what does that mean? A dependent administration is a game of mother may I. If I want to sell a house, I've got to post notice. I got to go back to the judge, ask for permission to sell the house, then put the house on the market, then go back to the judge and say, Judge, I now have a contract. Will you approve the contract? And then the judge will hold a hearing. I go back, I sell the house. Hopefully I'm within the closing period. And then I have the money in the estate. But I'm not done yet. I've got to go back to the judge, ask for permission to be able to give the money to the family. That is 3 times I've had to ask the judge at minimum for permission to do anything. What's a receivership? Well, that's when the judge says, I don't trust any of you, and I'm going to hire somebody else to take care of the property, whether it's an attorney or a corporate trustee. Somebody, not you, is going to be in charge. So the other questions I tend to get for a lot of folks is, do I ultimately need a trust? And I tend to get a lot of these questions because most people are coming in from California. And I love you guys from California, but you really drive, you ask a lot of really funny questions that we don't really care about as much in Texas. And let me answer a real quick question. So if we have a written will by an attorney, then why do we have to probate? And again, the reason is your will, and this document more or less is it's just a piece of paper. The will by itself has no legal significance until a judge admits it into probate and issues letters of administration or letters testamentary. If you have a will, it's called letters testamentary. If you don't have a will, it's called letters of administration. And if you have a will, but no one else, but there's the defect, then it's still letters of administration. So there's some key words about the difference between the two. But again, the document by itself has no legal significance. You cannot walk into a bank with a will and just say, recognize it. They will ask you, show me the order, show me the letters. And then you'll say, oh, I don't have those yet. They'll say, come back when you do. How much does it typically cost? It depends on what you're trying to do, but generally speaking, it could cost anywhere from $1,000, $1,500 on the low end to maybe $5,000 to $6,000 without a will. I think on average, if you were doing a simple administration, and what I mean by simple is you're transferring maybe just the house and something else, then maybe you can do a probate by itself within $3,000 to $4,000 or so. And again, people come and it's like, why does it cost so much? And well, let's go through and probably talk about that. Probating a will isn't just about getting letters testamentary. There is a whole administration process afterwards, which is I have to notify all the creditors. I have to notify all the beneficiaries. I have to file an inventory. I have to file a compliance statement saying that I've notified everyone. And that's assuming there's no creditor claims. So oftentimes after someone dies, you'll get a lot of notices, usually from DMC or Midland Funding or any number of banks saying that this so-and-so died and they owe us money. Well, guess what? There is a whole process involved with that. And that's just the creditor side. If we're talking about transferring assets, whether we're dealing with life insurance policies that don't have a beneficiary designation, whether we're transferring title to real estate properties, cars are a fun and doozer, in fact. But ultimately speaking, there is a lot more involved than simply having a will. And why, I keep emphasizing this a lot. The will by itself is a tool. It's a tool to help transfer property. But by itself, it's meaningless. You need the letters. And so for a lot of attorneys, and even for companies like LegalZoom, Rocket Lawyer, and everything else, yeah, it's really cheap to write a will. But that's because they don't have to do the probate side, which is the hardest part. So that's how much it costs. Now, there's another question is, should I set up a trust for my children, all minors, rather than a will? And the answer then is it depends on how old your children are. And so I actually just, and again, I love these questions because, again, I just talked to somebody today about that. They've got 2 minor children, roughly about elementary school year age. And so my first question ends up being, so my second question after asking how old are your kids, my second question is, well, how's your health, right? I mean, do you have cancer? Do you have any debilitating diseases that we need to do? What is your prognosis for the next 10 years? And so reasonably speaking, for younger families with younger children, without an urgent need, there's not as much of a need to set up an immediate trust today. And the reason why is a lot of wills will include what's referred to as a contingent trust. That is, if I die and my minor kids are not of age, whether it's 18, 21, 25, 35, I've had a client that said it was 45, before their kids ever get their money. If they have not qualified to receive the money outright, then a trust will be created on their behalf and that's what would happen. And so again, it's not necessary for some families to have a trust exist today. It may exist later. In fact, I talked to my brother because he's my trustee, and I asked him, hey, do you want to open up that bank account today? And he said, well, does the bank have any money? And I said to him, no, I mean, that's where my life insurance goes if I die. And so he just said, oh, so just hear me back, Jack. You want me to open up a bank account without any money and to file taxes every year? It's like, well, when you put it that way, I mean, what do you want to do? It's like, no, just wait till you die. And so that's the question is, do we need actually administration today, or is it something that we can do later? Okay, so when we talk about trusts, we tend to look at trust often for reasons not related to trust. Again, great question what was just asked, because that's exactly the reason why a trust is more useful. And what that means to say is we tend to look at trust, especially in circumstances when somebody cannot manage money on their own for one reason or another, because of a disability, because of age, because of a specific need. So for instance, if you have a family member who is going to rely on Medicaid, that family member as an individual cannot earn more than $2,166 or so. I need to double check the 2021 numbers because it's basically $2,000 and change. But the idea is this: if I make too much money, I can't qualify for Medicaid. And if I have too much money, right, not just earn too much, Medicaid only allows you to have $2,000 to your name. And so imagine that you're an elderly parent with a disabled adult child. Parents may be wealthy, but their child will never be able to work. Parents die. Under Texas law, everything would be automatically given to that surviving child who is disabled. Upon the parent's death, that child becomes immediately, within reason in terms of how much time it takes to process the paperwork, would be ineligible for Medicaid, because by the time the 30-day rolls around and that money shows up their bank account, Medicaid will say you're now no longer eligible. Or, we talk about the kids. You have minor kids. They can't have money. So we need trust designed for them in a way, because not for tax reasons, but because of control and access and ownership, right? I'm going to keep just harping on those three words in many ways: control, access, and ownership. That's what you want to think about. So here are continuity of management, creditor protection potentially, as well as eligibility for government benefits. In fact, there are a number of trusts that exist. I'm just going to give you kind of a menu of different trusts. And they're all more or less the same thing. And what I mean by that is a trust is an agreement between person A and person B on behalf of person C. Person A, B and C could be the same as A, and it's all interchangeable. It's kind of a game of musical chairs. But the whole point is, between A and B, I agree to hold this money on behalf of somebody else. And that's a trust. Simple and said, that's a trust. But whether there are tax benefits for setting a trust, different question. Whether there are specific provisions that we need to do for government benefits, separate question, right? Revocable trusts are typically known as living trusts, for instance. Irrevocable living trusts are usually done to remove property from the grantor's estate, for instance, or alternatively because we just need to lock it up. For instance, a divorce proceeding. You may have a trust between spouses that ultimately say, if we get divorced, then the terms of the trust are no longer changeable. We can no longer amend it. It's basically like a pre-divorce agreement, or a better prenuptial agreement, for instance. There are also elder care planning trusts, right? We just talked about the special needs trusts, whether it's funded by a third party or if it's self-funded, for instance. You may need a trust to be able to be eligible for VA benefits. You may also need a trust to be able to participate in able or special accounts that are managed by nonprofits. And so there's a number of minimum 7 different trusts available just for elder care issues. There are, of course, tax planning trusts. There are alphabet soups of different trusts, whether, for instance, intentionally defective grantor trust are kind of created in such a way where the grantor ends up still having to pay the taxes instead of the beneficiaries outright, for instance. There's an irrevocable life insurance trust in which we basically create a trust to buy specifically life insurance policies because life insurance policies are part of your taxable estate. There are qualified domestic trusts known as QDOTs, and that's because if your spouse is a foreign national or even a green card holder, you may want to put this money into a trust because not all money can be given to spouses who are not U.S. citizens. So there's another question, which is if you had a new account which we forgot to add to the trust, and if I died, and there's a trust, we still have to go to the probate process. The answer is maybe. And what do I mean by maybe? Trusts can be funded with existing accounts, which means to say that rather than have it being a bank account under the name of Jack Fan, I now actually say Jack Fan as trustee of the Jack Fan Trust is the account holder. But oftentimes, some of my clients will not go to the extra step of opening up a new bank account. And so if you have a bank account under your name, your wife's name, or anyone else's name in general, you may want to look at making sure that the POD designations go to the trust. Basically, point it to the trust. Because again, if you point it to your spouse, it goes to your spouse. If you point it to your children, it goes to your children. If you forget to name anyone, then that's where you need probate. So do I have to necessarily probate it with the trust? It really depends on how your account is set up, which is why I go back to the very beginning of my presentation, which is to say, estate planning is not about writing the will. It is not about the pieces of paper that someone throws in front of you to sign. It's about understanding how your assets actually move upon death or disability. And so there's another question is if I die, would the ACA surcharge tax affect the trust? And if you could probably explain what the ACA refers to, because ACA for me means the Affordable Care Act, and I generally don't see how Medicaid or Medicare or even medical insurance affects the state plans. If you're referring to MERP, which is the Medicaid Estate Recovery Program, that's possible. But again, if you could explain what ACA means to you, I would really greatly appreciate that. Now, again, going back to further the alphabet soups of trust, there are a number of trusts for tax planning purposes as well, which gives away money for charity. And if you thought that I was joking about the Shark Fin Charitable Leads Trust, no, that's actually a trust itself too. What Shark Fin actually means, it's the way that money is distributed. It's basically a balloon payment. So money a little bit, but then at some point it grows really fast, and then it cliffs dives upon your death. So yeah, there's actually a shark fin soup. I guess it depends on what you think of a shark fin. It could be also a dolphin fin if you really wanted, which goes this way instead of this way. And then there are also asset protection trusts. One example is a gun trust for clients who really want to own guns, especially guns that require specific licensing. You end up not having to be able to own the gun outright as Jack Fan. You've got to put it into a gun trust where the trust as the trustee owns the gun. And even though I, Jack Fan, am the trustee, I'm wearing a different hat here where, again, it's not Jack Fan, it's Jack Fan with a hat as the trustee who owns the gun. Life insurance trust, for instance, again, it's something to consider, but we won't talk about in great detail right now. So I've spent an hour almost talking about different things to think about. And it's my hope that you have questions at the end of this conversation. Talk to an attorney, because attorneys who are experienced in probate understand what the judges want to see. It is not enough to have a piece of paper unless you know how that piece of paper is going to be recognized by the bank, by the title company, by your business partners, by your own family members. Let me share with you, for instance, just the dumbest fights that I even have. A piano. And what do I mean by a piano? Dying wishes of the parent is a particular musical instrument be given to one of his children. His children end up fighting over the value of the piano. Does it come as a direct gift to one of the siblings, or does it come out on below, which is you have to divide everything in half? And so the moral of this particular story is never assume that your wishes will be carried out after you're gone. You truly will never know. But the family fighting over these assets, that's what really tears people even further apart. What should have cost, there was a question earlier, how much does it cost to probate? We thought it was going to be a standard probate. Everyone was going to just be fine. And maybe, let's say, $3,000 to $4,000. If I truly billed every single minute that I was involved in this fight, it ended up being $20,000. I ended up discounting it significantly because I just felt bad knowing that, look, we really didn't have to go through all of this. I will even take a significant cut from legal fees so that you won't fight. And I truly believe that may be the olive leaf that was necessary so that the kids stopped fighting. Because once they realized how expensive it was to keep fighting, everyone just said, you know what, let's just settle this. And so please, if you have questions, put them on the chat. I'll be happy to stick around even after the hour, just kind of answer your questions here and there. But let's answer some of these questions first. If my parents' trust has been dissolved, would I be notified, if at all? The answer is, it depends what it says. And again, I know everyone hates it when lawyers say it depends. So the answer is this. In most trusts that are written, it should include a provision that says if the trustee is deciding to wind up a trust and to effectively dissolve it, then they need to notify the proper entities, sometimes the Attorney General's office actually, as well as the beneficiaries of that trust. A trustee by themselves oftentimes can't do anything drastic without notifying somebody, whether it's a trust protector or whether it's the beneficiary. You really have to look at the terms of the trust itself to see what it says. And if it doesn't say it in the trust, then you refer back to the Texas Trust Code, which provides the default provisions. So the follow-up question about the ACA was, in fact, about the Affordable Care Act, and that it gets applied to the trust. Not sure if it's above 11.8 million. So again, the Affordable Care Act doesn't actually affect the exemption limits or even tax on the estate. So I think that the question that the person was really referring to ends up going back to the Tax Cut Jobs Act, the TCJA. The TCJA has more of an effect on the estate overall. And again, feel free to contact an attorney that's part of the Texas Legal Network because your plans typically involve a consultation. In fact, what I really, without being, I understand I'm a provider, but I'm not the spokesperson for Texas Legal. But what I like about Texas Legal in some ways is that you have a way to talk to an attorney without having to worry about having to pay for an attorney for every single minute. That is the one thing that I hear from a lot of people generally, that I don't want to talk to an attorney because I'm afraid that as soon as I speak up, they're going to grab a stopwatch. And I hate for that to happen, which is why I am happy, and I'm sure most of my colleagues who are legal providers on this network are happy to answer your questions, because we want to be able to help out. Whether it's to tell you, yes, this is a legal matter. No, this is not a legal matter. No, you can just go talk to this agency instead, and you'll be fine. I have so many times that I've just basically said, no, fill out this form and you're good. And they're like, oh, I didn't know I could just do it that way. It's like, yeah, just fill this form out. You don't even need to talk to me. You're good. But that's the value of having an attorney, is just even being able to talk to an attorney for this advice. There's a separate question, which is asked, if a house is being left to my siblings and I, who would be the executor, maybe? Okay. The house is being, who is financially responsible for fixing up the house? Sorry. This is a fantastic question, because everyone is looking to sell houses, and this is why I hate multiple owners. So one of the things I really hate is when I see wills that basically just says outright, because it basically says they have never really given it some thought as to what's really going to happen. If it's all to my spouse, I'm okay with that, because again, it's one person. But if it's to my children in equal shares, nobody knows what's to do anymore. There is fights ad nauseum about who's in charge. So let's talk about it. If a will names the beneficiaries of the estate, usually the residual clause, to all of my children in equal shares, or their descendants, doesn't matter, and there's two or more owners now of the house, what happens is that everyone is responsible for the house, the taxes, the upkeep. Fixing it up, no one's responsible, no one's putting down the money. Now, the one caveat would be the executor, because the executor tends to be the person responsible. So the reason why then I go back one step back is, well, maybe it's not the worst thing in the world. I always ask, who's going to be in charge? Is this child, is this person that you're naming as the executor, the person who is most responsible? So if you have an estate that has actual assets, the executor can then liquidate other assets, maybe sell the car to build, to remodel the house. They can use the bank accounts that are in the estate, assuming that there are bank accounts titled to the estate. But if there's money in the estate to fix the house, to pay the taxes, then we have a solution. You know, I go back to that house I was talking about that we sold and we ended up having to pay a lot of taxes. But this is the point that I'm trying to make here. Why was it such a hard part? The reason is, when we probated the estate and after we went through all of the financial accounts, we realized the estate had nothing except the house. No bank accounts, no retirement accounts, no cash. We wanted to fix the house. We couldn't because we didn't have the money. We had to basically loan or find money from family just to fix it up and reimburse them and promise, if you give us the money to fix this up, once we sell the house, we'll give it back to you, right? That's a big promise. People are really hesitant sometimes. And so the idea is this: if you have enough money left in the estate to be able to do something like that, not a problem. But if there's no money left, then you will almost guarantee a fight over who's going to pay the taxes, who's going to pay for repairs. And I just had something like that happen because we were trying to sell the house, and then one of the siblings wanted to renovate the house without agreement of the other siblings. So basically one person basically just said, I'm going to go fix the house so we can sell the house at a higher value. We got into a large argument afterwards because of the fact that no one else agreed to fix it. No one else wanted to chip in after the house was sold. So problems abound. I'd like to continue to ask if there's any questions. Please feel free to either put it on the comments. Please feel free to reach out to my office. Please feel free to reach out to Texas Legal. And there is a network of attorneys across the state of Texas who are happy to be able to help you and provide guidance as to what you should do next. So with that being said, I thank everyone for giving me the time to learn a little bit more about the estate planning process, what you should think about before you talk to an estate planning attorney, what you should think about in general for not just yourself, but really for your family as well. Thank you so much.